So I hope that over the medium to long-term future, the court can gradually be brought to change its position on these issues, but that will be a slow, incremental process, not one that's likely to occur within the parameters of the current economic crisis. I think also that we cannot rely on state governments to constrain the growth of federal power during the crisis because, among other things, they actually like federal power, at least when it gives them money. So the interests of state governments often are actually inimical to the interest of preserving federalism. Where I think there is some hope is with respect to two different areas. First, if you look at the general public in all sorts of surveys, there's a great deal of distrust of the federal government. Just recently, a Gallup poll showed that some 57% of the public think that the federal government is already doing too much. And there are other surveys that Rick Hills has written about which suggest that most people tend to trust their state and local governments at least somewhat more than the federal government. A second possible area of hope for federalism is ironically the fiscal crisis of the central government, which according to the Obama administration and almost every other observer is going to become very severe over the next 10 to 15 years. As the feds begin to seriously run out of money, they will simply not be able to continue to support the states in the style to which the states have become accustomed, and that over time will impose some genuine constraints on what Congress can do and will force the states to some degree at least to pay their own way. So I think in the short run, the economic crisis poses serious threats to federalism, not all, unfortunately, of which can really be prevented. In the medium to long term, I hope that there is much to be done and that can be done to hopefully revive federalism and impose tighter constraints in federal power than currently exist. Thank you.
Thank you, Ilya. Our last presenter is Rick Hills, professor of law at New York University. Before that, he was at University of Michigan Law School. His academic focuses on the problems and promise of decentralization. He has a degree from Yale College and Yale Law School. He clerked for Judge Patrick Higginbotham in the Fifth Circuit. He has argued that, quote, subnational legislatures are more likely to promote democratically accountable local autonomy than national legislatures. Rick. Look forward to hearing from you.
This is a weird existential experience for me, because when I'm invited to these panels, I'm usually the federalism nut. They need somebody to represent the interests of federalism and say, call Rick Hills. He'll always tell me something wacky in favor of federalism. And that indeed is my reputation. That's how I write. I'm a genuine die-hard believer in not only federalism, but judicially enforced federalism. But, you know, first of all, to have everybody be a federalism nut here would be to pile on Malcolm, and that's just not right. And second of all, Dean Reuter said, Rick, we need somebody to make this a two against two debate. So here I am teaming up with Malcolm to take the position that judicially enforced limits on the spending clause are not merely implausible, but unadvisable and unnecessary. And those are the 3 points I want to make really quickly. The first point I want to make is that federal courts simply can't enforce limits on Congress's spending power. Second point I want to make is they shouldn't. And third is they don't need to. Now, before I say all of that, I want to say one little word about U.S. history and the spending clause. There are limits on the spending power, and they are indeed constitutional limits. And indeed, I would agree with Dean Eastman, they are rooted in the General Welfare Clause. But they have never been enforced by courts. They've been enforced by presidents. In the antebellum period between Jackson's Maysville Road veto message of 1830 and the Buchanan veto messages that were quoted by Dean Eastman, presidents dramatically vetoed federal spending as part of a Democratic Party ideology encapsulated in Democratic political platforms from 1841 to 1861. They would veto spending not only on stuff that we'd normally think of as local pork, but even on clearing water for navigable waterways. Polk said that was not a federal interest. Polk was one hard limiter of federal spending. So indeed, there is enforcement of limits on the spending clause, but they come from the political branches and always have. Indeed, judicially enforced federalism, as far as the spending clause is concerned, has only had one good year, and that's 1936 in the case of Butler, one of the more incoherent opinions ever written by the U.S. Supreme Court. The first, Justice Roberts. So the notion that there is a history or a track record from the framers judicially enforcing limits on the spending clause, I think is wrong. In fact, Madison in his famous 1816 bonus bill veto said, The general welfare clause is not a legally manageable standard and cannot be enforced by the courts. That's why he vetoed the bonus bill. And indeed, Jackson would agree that there was no legally manageable standard. He was no ways in favor of giving the federal courts supervisory power over the budgets of the federal government. He hated federal courts because they were manned by his archenemy, John Marshall. So the notion that there's any sense in which the federal spending power of the budget can be policed by the courts, as drawn from precedents from U.S. history, I think, is mistaken. Now, here's why federal courts can't. It's not merely that they haven't. And by the way, they haven't in the United States, they haven't in Australia, they haven't in Canada, and they haven't in Germany. There's not a single federal regime in which the Constitutional Court plays any significant role in limiting the national government's spending power. I don't think that's a coincidence. Here's why federal courts can't limit the spending power. The spending power is used for what is, I would call, mixed public goods. Some things are totally national. We don't want subnational governments involved, national defense. In which case we simply enumerate a power giving the federal government exclusive control over, say, diplomacy or national defense. Call those national public goods. Some things are totally local, like setting up a precinct police station in the 84th precinct of New York City where I live. We don't want the federal government paying for that because, after all, I should bear the cost for all the good reasons that Dean Eastman mentioned. But a lot of things are mixed. That is to say, there's a predominantly local interest, but there's also a federal interest, and drawing a line between them is very difficult. How do we manage those interests? Well, we want to give subnational jurisdictions some kind of financial incentive to take into account the positive externalities that their local public good produces. So, for instance, take, for instance, a World Trade Center memorial. The World Trade Center is a symbol for the entire nation. Millions of tourists are visiting World Trade Center from outside of New York City. It produces enormous psychic benefits for them to think about this as a place of national mourning, of national remembrance, etc. If someone were to say the federal government or the national people have no interest in the World Trade Center memorial, I think that most of us would say that that was rather odd. But we don't have an enumerated power for the national government to create national monuments or memorials. They can create forts and arsenals and docks, but not national memorials. But they do have the spending power, and they can give us a little money to defray the costs of protecting all of you when you visit us in New York City. Now, is that a legitimate purpose for the federal government? Any federal regime that said it wasn't would be marked as lunatic by any competent political scientist or economist. And those are even people like me who believe in federalism. So the question is, how much of a federal interest is there? How much money should New York City get? Well, that's very difficult because, of course, we also get a lot of benefit from you folks. I mean, you promote tourism, we can charge you a lot of money, hotel occupancy taxes, etc. So figuring out exactly how much extra stimulus we should get for providing a spillover benefit to the nation is an impossible line to draw. Now, I want to illustrate how impossible that line is to draw by drawing on a Sixth Circuit case that recently came down, in which Judge Sutton wrote one of the opinions, in which the Sixth Circuit divided 8-8, deadlocked, over the question of No Child Left Behind. Now, the No Child Left Behind Act is essentially an act in which the federal government gives $14 billion or so to the states and their subdivisions in order for them to pay attention to low-performing students. There's very few strings attached to the money. Essentially, all the recipients have to do is monitor that the kids make adequate progress through standardized tests, and if you don't make adequate yearly progress, then they have to take some kind of measure, charter schools, tutoring, transfer the kids, etc. There is a constraint that they have to spend it on low-income kids, and there's a reason for that. There's a national interest in making sure that we have racial, ethnic, and class equality in education. That national interest has been widely recognized by both political parties and the Supreme Court since Brown versus Board of Education. And that is clearly the national interest that NCLB is trying to advance. A national interest in making sure we have educational equality so that the indifference of local political machines or teachers' unions do not cause kids to fall behind in school who don't have the political clout to fight entrenched political interests. Okay, so that's NCLB. There's a national interest here in making sure that we budge school districts to spend more on low-performing kids. There's also a huge local interest as well, because obviously an elected school board cares about all of its students, at least to some extent. Now, how do we know how much money we need to bribe the Pontiac School District into making sure that their lowest quintile of kids performs well? I have no idea, and neither does the Sixth Circuit Court of Appeals. And so we have a statutory provision in the statute that sort of mimics constitutional requirements against unfunded mandates. The particular statutory provision reads, it's section 7907A, nothing in this act shall be construed to authorize an officer or employee of the federal government to mandate a state or any subdivision thereof to spend any funds or incur any costs not paid for under this act. This is an anti-unfunded mandate provision.
How do we know that the Department of Education is requiring a school district to pay funds that were not paid for under the Act?